Ну, я тоже. Давай заново и пойдем уже нормально.
Ну, перезапускать мы не будем. Мы обрежем просто.
Ну, что ты хочешь обрезать?
Я не бачу твою назву. Це буде Україна.
Не
Это
видно.
зум, он же сам обрезает картинку. Камера дает много. Камера вот дает. А зум не знаю.
Так.
Ну, на ютубе я буду видно.
Такое костечко будет, как обычно.
Чому?
Ну, тю. Я ж о чому говорю, чого ти?
Все одно українець розбере цю фразу, навіть якщо вона буде в міліметрі.
Хорошо. Давай сначала.
Давай сначала.
Все, херня, давай.
Миша, все хуйня, давай по новой. Текст просто по-дебильному написан, понимаешь?
Ну, все йшло добре. Ти хотів сказати, типу, я передаю слово?
Да.
I pass the word.
Да. Все.
Хорошо.
Скажешь, когда можно.
Можно.
Good day, everybody. I'm Nikita Kacherba, lawyer advocate from Interlegal Ukraine. With my colleague Irina Maltseva, we're pleased to welcome you to our next webinar. Today, we will talk about enforcement and foreign court decision and also arbitration awards. We are sure that the topic is relevant and interesting both for those who first encountered this case topic, as well as for those who already have experience with recognition and enforcement of the awards. Because we will speak about the recognition and enforcement in Ukraine, in Turkey, in Romania, Georgia, and also in United States of America. Before we start, just a few words about our company. So our key practices is shipping, transport, trade, corporate and taxes, and also yachting. We have a wide network of associated offices around the world, more than 30, which allows us to provide services to our clients almost anywhere in the world. Definitely expect Russia, because there is no right and no law there. Also, we have our own offices in Black Sea region, also in Ukraine, Moldova, Romania, Bulgaria, Turkey, and Georgia. Says nothing better about us than our performance, our key numbers. We have more than 25 years of practice and experience. We have around 1,000 client cases per year. We work around the clock for our clients. We have more than 60 experts in Odessa office. We get more than 15 arbitration awards per year. As our practice shows that 70% amicable settlements in the disputes, and we have 25 plus arrested and released vessels per year, and more than 100 yachts under the maintenance. So we are ready to start. I pass the word to Irina, and Irina, the floor is yours, please.
Dear colleagues, good day. We are happy to see you in our webinar. We hope that you and your family are in safe. And today, let's talk about recognition and enforcement of foreign court decision and arbitral award. So first of all, we need to understand the types of judicial awards to be enforced. First, it's a local court decision. It's quite simple type. It's about when the consideration of dispute and the enforcement of the court decision are conducted in the same country. For example, the dispute is considered by the court of Ukraine, and the enforcement is conducted in Ukraine by the place of the debtor. For example, the debtor is the resident of Ukraine. So it's quite simple, understandable. The second one, foreign court decision. It's an interesting moment. Usually the parties of the contract stipulate the place of dispute resolution in the contract, like the separate clause or just like provision of the contract. As per these provisions, the party indicates the certain court, for example, the court in Romania, and the dispute will be considered in the court of Romania. And if the debtor is the resident of Ukraine, the foreign court decision must be conducted in Ukraine by place the debtor of the debtor. International Arbitration Award. It's also about the party's will. So the party have the right to indicate in the contract the arbitration clause with the details, the name of arbitration, the language of arbitration, the material and procedural law. And it's important to say that usually arbitrations provide us with the recommended arbitration clause. And we always advise our clients to use these recommended arbitration clause and to set it into the contract. If with the first type of court decision all is clear, we believe that we need to clarify in details the procedure of recognition and enforcement of the second and third decision. So the second and third decision require the procedure of obtaining permission for enforcement. This procedure is called recognition. How does it work? We need to apply to the court, file the petition on the recognition of court decision on the merits to the court, and this petition is considered by the court under the defendant's location or defendant's property location. If your claims are satisfied, the next stage is enforcement proceeding. It's important that your counterparty has the right to appeal the court decision on recognition in appeal and cassation proceeding. But let's talk about the situation when you received the decision with satisfaction of your claim. Enforcement proceeding. Usually, the enforcement proceeding is conducted via state enforcement service. In different countries, it has different names. For example, in Turkey and Romania, it calls bailiff officer. In Georgia, calls National Enforcement Bureau. In Ukraine, it calls a State Enforcement Service. However, it's important to state that in Ukraine, we have the additional option, private enforcement officer. Usually, we advise our clients to use this option when the debt, the amount of debt in the currency, for example, euro or dollars. Why? Because if the debtor is located in small town and state enforcement service is located in small town, usually the state enforcement service doesn't have the bank account in currency. Meanwhile, private enforcement officer has a right to open bank account in any currency without any problems. The procedure of recovery is the following. Execution or private enforcement officer collect the debt to his bank account and then transfer this amount to the claimant. So if the state enforcement service doesn't have their bank account in currency, so this mechanism will not work. More in detail about recognition and enforcement proceedings, my colleague Nikita will tell you further. So, procedure of recognition of foreign court decision and arbitration award. Usually, this procedure is similar. The difference is in a regulation. If we are talking about foreign court decision, this procedure of recognition is regulated by a local legislation. If we are talking about arbitral award, this procedure is regulated by Convention on the Recognition and Enforcement on Foreign Arbitral Award. The difference is in the jurisdiction, in the court. I mean that if we need to recognize the foreign court decision, we need to file petition. We need to file a petition on recognition to the court of first instance. If we're talking about arbitration award, we need to file the petition to the appeal court. Sometimes it can be another court. So we understand that the procedure is quite similar, and we of course understand that this category of cases of court consideration has own requirements of the legislation, and it's important to you to be provided by legal support by professionals in this area. Why? The legislation provides grounds for rejection, recognition of foreign court decision and arbitral award. So the small mistake can just ruin all your case. For example, if your counterparty wasn't duly notified on case consideration, or he didn't receive all needed procedural documents, you can see the list of grounds on the screen now. So it's important your lawyer know the procedure, know the requirements of legislation, and know the risks of failure of fulfill these requirements. Black Sea region countries. All these countries are party of the Convention on the Enforcement and the Recognition of Arbitral Award. As Nikita said earlier, we have our own offices in the Black Sea region, so we can provide you with our legal help, legal support in these countries. Let's start from procedure in details in Ukraine. And Nikita, the floor is yours.
So, colleagues, we will start from the enforcement in Ukraine. The procedure is similar as Irina told. The main difference it's regarding the with foreign court decision and with the decisions of international arbitration. If we try to recognize the foreign court decision, we should apply to the first instance court. And if we want to recognize the International Arbitration Award, we should apply to the Kyiv Court of Appeal. Yes, also in Ukraine, it's possible to appeal after we receive the court decision of enforcement or of decline of enforcement. So it's not very interesting or new information for you. Yeah, the main and the interesting point in enforcement in Ukraine is that both the convention and the legislation of Ukraine provide for the need to provide to the court original arbitration agreement or notarized copy of such agreement. As you understand, most contracts are concluded by exchanging scans in email correspondence, yes, and without subsequent exchanges of originals. This may create additional manipulation in favor of the debtor, so we always recommend exchanging originals. But don't worry, in case if you have only the scan of the agreement, yeah, we know how work with the defendant's objections, and it's not a big problem, but only you should keep it in the mind when you when your party for the contract from Ukraine. Yeah. So regarding Ukraine, that's all, and I will pass the word to Irina. Yeah, thank you.
So let's talk about Turkey. I will tell you about some peculiarities of this procedure of recognition in Turkey based on our recent case. The case consideration on the merits was conducted in Ukraine in International Commercial Arbitration Court. We were representatives of the claimant, and the debtor is the resident of Turkey. We obtain the court decision satisfying our claims. So after that, we applied to our office in Turkey with the request to provide us, our clients, with the procedure of recognition and enforcement of court decision. We were informed that in Turkey, mediation procedure is a mandatory point. This stage is the great option for the parties to solve the dispute amicable without further court considerations. In our case, the party of the dispute didn't reach the agreement under the case. So we were forced to go to the court with the relevant petition. We received the court decision satisfying our claims. However, the debtor was disagree with this decision, so he used his right to file the appeal to the court. Now we are at this stage, and the case consideration is continue. So we will tell you about this case in future. The next stages is similar to Ukraine. Enforcement in Moldova, recognition and enforcement in Moldova. These procedures are similar to Ukraine. However, based on our also recent case, I would like to tell you about peculiarities which we face too. Our client, Russian, resident of Russia, applied to us with the request for the help. So we provide the client with the legal support in court of Russia. This court has name arbitration court of certain district. Our claims were satisfied. So as far as this is court, we know that we need to go with the petition to the first instance court. This first instance court of Moldova satisfied our claim, satisfied our petition on recognition of the court decision on the merits. However, the counterparty used this moment with the name of the court in Russia and filed the appeal, claiming that the petition on recognition should have been considered in Chisinau Court of Appeal. Surprisingly, we discovered that Court of Appeal satisfied the appeal of the debtor. Of course, we were disagree with such decision, and we applied to Supreme Court with the several appeal cassation. However, due to Russian aggression to Ukraine, we stopped legal supporting of these clients. So now we don't know the results of this case. Enforcement in Georgia, recognition and enforcement in Georgia. The procedures are also the same to Ukraine. However, the interesting moment that the recognition of the International Arbitration Award must be conducted in Supreme Court of Georgia. So it's not the appeal court, but Supreme Court, and it's the main point in this case. Because if you choose not correct court, you will face to the situation, you may face the situation with the case in Moldova. So you can see that the procedures are similar, but all countries has their own peculiarities. Usually, the peculiarities, the differences is in the jurisdiction, the court who considers the case, the terms, court fee, sometimes it bailiff fee, it may be also the list of documents are required for some state body, but generally the procedures are the same, and now you can know what you can expect from these procedures in different countries. And we as lawyers lawyers who have the offices in Black Sea region can provide you with the legal help in any of these countries. Also, I want to tell you about that we have the associated offices all over the world. Nikita earlier told you about this, and we would like to pay your attention on the fact that we can also provide you with help in different countries all over the world. Nikita will tell you in details the procedure in USA. Nikita, the floor is yours.
Colleagues, surprisingly, but the United States is also a party to the New York Convention, as you understand. Yeah, therefore, the procedure is not much different from those that Irina talked about. Some peculiarities is it's a determination of the competent court. Yeah, it's due notification of the defendant by the court. Also, if the debtor evades the notifications, there is an alternative method of service. Yeah, the formal verification of absence of grounds for refusal of recognition, the opportunity to consider case without the participation of the debtor, if in this court procedure stage the debtor continued to evade the court proceeding. Yeah, it's a possibility to recover court fees and attorneys costs, and also it's the option for the losing party to appeal against the decision. So as you see in Georgia, Turkey, USA, Ukraine, the procedure is almost the same, but with some peculiarities. So that's all regarding the USA. Basically, I think that's all that we wanted to tell for you. We thank you for attention and participation. If you have any questions or clarifications, please do not hesitate to contact us. Now our contact details in your screen, and we will wait. Yeah, thank you very much and see you soon. Yeah, thank you. Bye-bye.